Should you use the word retainer or deposit in your photography contract? Or would booking fee or reservation fee suffice? I'm answering this frequently asked question in today's video. Hi there. If you are new to my YouTube channel, my name is Paige Griffith and I am the CEO and lead attorney behind the Legal Paige, which is an online legal education platform and contract shop for small businesses. We help you get legally legit in no time without all the overwhelm. Let's start off with what the words retainer and deposit mean, especially in a legal sense. A retainer is a fee paid for in advance to hold your services. Typically, a retainer is non-refundable and should be seen as securing services for a future date or time frame. Case law precedent for the word retainer is actually rooted in attorney-client law. When attorneys take an initial retainer from a client, that's a flat fee amount for future services they will then be performing for them. They then deduct their hourly rate from that retainer, so it's basically a prepayment. Thus, retainer fees can also be used to cover the initial costs of the services being rendered by you. But for most service providers, the retainer is truly a retainment for your services on a certain date or a time period, and this would be whereby no one else could book your services. A retainer should account for the amount of work you would be potentially losing on that date that you secured for your client should they cancel or reschedule. This is called an opportunity cost in legal speak. Also, some service providers, such as planners or virtual assistants or certain types of photographers, can also point to a portion of their service hours that they should be accounted for in the retainer, such as your time spent to book your client, set up questionnaires, communication back and forth, immediate documents that you may deliver, etc. On the other hand, a deposit is a payment towards the total fee for services. Typically, though, a deposit is refundable because once the service has been completed, you would give a deposit back. Or a deposit could also just be applied to the client's total costs. And if the total amount of services that you are actually supposed to be delivering isn't delivered because it's canceled or rescheduled, then oftentimes that deposit is refunded back. So the term deposit is actually most seen in landlord-tenant law. We're all very accustomed to paying a security deposit in order to secure our rental for potential damages that could occur. Then you likely have to pay the additional first month's rent on top of the deposit. So it's basic knowledge then that the deposit is refundable to the renter upon checkout if no damages have occurred and all rent has been paid. Thus, the term deposit gets sticky for service providers. If you don't actually perform the services, like I mentioned, a cancellation or rescheduling happens, then your client could ask for their deposit back since it was supposed to go towards the total fee for the services that you never performed. Also, deposits can often lead to clients arguing that the deposit should potentially be transferable because the services were never performed and that you could perform them at a later date because they already put down the money. Using the wrong term in your contract will have different implications when being reviewed in a court or, say, by a mediator or arbiter interpreting your service contract during a dispute. Courts will look more towards how the clause language works than the labeling of the term itself. So make sure that you explain that it's specifically used as a fee for holding the date, that it's non-refundable, and also serves as liquidated damages in the event of a client cancellation. I suggest using the term retainer because if you clarify what that retainer is for correctly in your fee clause, such as for booking X date or time frame out on your calendar whereby no other client can book you, and you qualify that retainer as non-refundable, you are better suited to ensure that that amount is actually non-refundable in a legal sense. It's all about the plain language in a contract. I am also okay with people using the terms non-refundable reservation fee or booking fee in service-based contracts. The one thing to remember is that whatever term you do choose in your contract, keep it consistent throughout. Don't interchange retainer and deposit because that will create mass confusion and often void certain portions of your contract. Now, I know I used the phrase liquidated damages earlier, so I just really want to hone in on what that term is for a second. Specifically, express in your fee clause that the retainer payment that the client is making at the beginning when booking you is an advanced payment for services, which will be deemed liquidated damages if a breach or cancellation occurs. Legally speaking, liquidated damages is an agreed upon non-refundable amount that a client pays as a predetermined amount of money that must be paid as damages for failure to perform under a contract. Most service-based contracts will use the term retainer plus language surrounding liquidated damages to make it absolutely crystal clear to clients that the retainer amount is only related to the retainment of services on X date, and that it amounts to liquidated damages should the client decide to cancel the contract or breach the contract in any way. My best legal suggestion for service-based businesses is to use the term retainer in your contract. It's more clear legally, and then you should also have that sentence or two explaining what the retainer is for and that it will amount to liquidated damages for your business if your client cancels or breaches. If you're wondering exactly how to draft a proper fee and retainer clause for your service contract, the Legal Paige has an extremely thorough one in our shop, and I've linked it below for you. And if you're interested in hearing more from me about contracts, specifically my 3 best kept contract secrets and my 4 things that you can do right now to have a better client contract that will actually protect your small business, head over to my free legal class at contractclass.com. Thanks so much for watching this video. Stay tuned for more. They come out every other week, and I'll see you in the next one.